This is an update on Trump's ongoing New York State criminal trial. I last discussed that criminal trial in a video about 3 weeks ago that I will link in the More section below. To briefly summarize the legal issue involved in this criminal case, Trump has been charged with committing a felony in connection with falsification of business records. The alleged falsification is the creation of business records that characterize the reimbursement of Cohen's $130,000 hush money payment to the porn actress Stormy Daniels as a legal expense. Falsification of business records without more is a misdemeanor under New York law. The falsification of business records can be elevated to a felony if the intent behind the falsification is to commit or conceal another crime. Since I posted that video over 3 weeks ago, the New York DA Alvin Bragg identified on April 23, 2024, what he called the primary criminal statute that the prosecution will use as the other crime. That statute is Section 17-152 of the New York election law, which I will refer to hereafter simply as Section 152. Prior to that statement, the prosecution had identified 3 alleged crimes as the other crime in a bill of particulars that included Section 152, with the other 2 being an alleged federal campaign law violation, such as exceeding the maximum contribution limit, which is what Cohen pled guilty to, and attempting to skirt New York tax laws by classifying the reimbursement as a deductible legal fee. The tax law angle is probably far too complex of an issue for the jury to understand. See, quote, the question of tax fraud in Manhattan DA's case against former President Trump, end quote, published on May 23, 2023 at the Just Security website. I think it would probably just be best not to even bring this up. Section 152 is much easier to understand for a juror. Section 152 is titled, quote, conspiracy to promote or prevent election, end quote. It reads as follows, and this is the entire statutory provision. Quote, any 2 or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means and which conspiracy is acted upon by one or more of the parties thereto shall be guilty of a misdemeanor, end quote, and that's it. When identifying that statute as the other crime, the New York the Manhattan DA, Alvin Bragg, made this statement, quote, there is conspiracy language in the statute. The entire case is predicated on the idea that there was a conspiracy to influence the election in 2016. And that conspiracy must be unlawful. Including this misdemeanor as the other crime that elevates the falsification of business records into a felony is apparently okay, since the statute does not require the other crime to be a felony. These issues are discussed in more detail in a recently published article, quote, old, unused, and twisty meet the obscure New York election conspiracy law that just might get Trump convicted, end quote, published by Business Insider on April 27, 2024. The DA, in my opinion, has already laid a foundation without Cohen's testimony that there was a conspiracy involving at least 3 persons to influence the 2016 election with the hush money payments. Some of that testimony comes from David Pecker and Hope Hicks. Handwriting on Cohen's bank statements made by Trump's chief financial officer, Alan Weisselberg, former chief financial officer. He is currently in prison. noted that the total payment to Cohen would be $420,000, which would be paid in $35,000 installments. The handwriting that has been identified as his handwriting in the trial had this breakdown of the $420,000. $130,000 was for reimbursing Cohen for the $130,000 he paid for the Stormy Daniels hush money payment. That was grossed up to $260,000 to account for the taxes that Cohen would owe on the $130,000 payment when treated as a legal expense rather than merely as a reimbursement. There was another $50,000 for claimed technical services provided to the campaign, and that was grossed up to $100,000 to account for Cohen's taxes, and then there was a $60,000 bonus paid to Cohen. The handwriting was admitted into evidence under the business record exception to the hearsay rule, and this would be a business record of Trump's, not Cohen's, even though the handwriting was on a Cohen bank statement. Handwriting by Trump's controller that was also introduced into evidence and who testified confirmed this breakdown. The first payment was for $70,000 covering January and February 2017. If Cohen was merely asking for a $130,000 reimbursement, there would have been no reason to gross up the payments to $260,000 to account for his federal and state income tax obligations for $130,000 that he paid to Stormy Daniels. The first check of $70,000, as I said, was for 2 months. It was not signed by Trump and was paid out of Trump's revocable trust account. The signatories to that account included Trump's sons and Weisselberg. Starting in April 2017, when Trump was in office as president, the checks were sent to him in the Oval Office. Each was for $35,000. They were signed by Trump himself during 2017 and drawn on his personal account, which required him to sign the checks. The two accounting employees of the Trump organization who have testified at the trial did not talk to Trump about classifying the hush money payment as a legal expense. Cohen may provide direct evidence linking Trump to that classification. Even without Trump's testimony or the jury disbelieving what he says on the subject, Trump did sign 9 of the checks to Cohen in the amount, each in the amount of $35,000 in 2017. There is proof that Trump was very involved in the particulars of payments made by him or his company. So the circumstantial evidence is that he would not be signing $35,000 checks to Cohen unless he knew exactly what they were for. I have seen images of invoices for the checks that categorized the checks as pursuant to a retainer. I did read several reports that Deb Tarasoff, who is still employed as a payroll supervisor, testified that the invoices from Cohen would have been stapled to the checks, which is important circumstantial evidence that Trump knew of how the payments were classified before he signed them. She also testified that Trump would occasionally write void on the check if he did not want to pay it. See the article titled, quote, Trump signed off on Michael Cohen's invoices after they were sent to the White House, account it says, end quote, published on May 6, 2024. Contrary to what many Trumpsters are saying, This kind of circumstantial evidence of Trump's involvement in the classification or approval of the classification can result in a criminal conviction. That proof is probably enough to take the case to the jury on Trump's involvement in the falsification of business records, but it may be troublesome for one or more jurors to convict based solely on that circumstantial evidence, assuming that Cohen's testimony is completely disregarded on this subject by the jury. So the issue is guilt beyond a reasonable doubt based on that kind of evidence, and so that can always be an open issue and could go either way, in my opinion. So there may be one or more other witnesses besides Cohen on Trump's involvement in the falsification. I do not see Weisselberg testifying at all, although he could probably provide some direct evidence of Trump's involvement in the falsification of the records. He would probably plead the fifth or just be totally uncooperative. One question about a potential witness, possibly an independent accountant for Trump, relates to whether Trump deducted the $130,000 grossed up to $260,000 paid to Cohen as a legal expense. Did he deduct that amount? Trump made a statement during the trial or during a recess in the trial that he did not do so. Did someone who was preparing his tax returns ask about it and was told not to deduct it, since it was not a legal retainer as shown in the documents? A third-party accountant would have wanted to receive the retainer agreement, which did not exist. Maybe there is someone who can testify on that matter that we do not yet know about.